All right, welcome to the 294th District Court. My name is Chris Martin. I'm going to call this morning's criminal docket. When you hear your name, please say present or here. Kimberly Betcher, Kimberly Ann Betcher. She may be running late. Mandy Jones, Laneria Miles, Ashley Olds, Ryan Smith. Sir. Cody Wheeler, Carlos Gatlin, John McLeod, John Houston McLeod Jr. Gregory Horton, Johnny McMinn, Thomas Norman, James Godwin, William Goldner, Jeremy Snelson, Donna Drake, Stacy Green, Nathan Ojeda, Kenneth Taylor, Reginald Young, John Dunlap, Lisa Cabernet, Tracy Jacobs, Brandon McClanahan, Wendy Price. Your Honor, Mr. Price is out. It's not. Well, so I just said sit out there. Okay. Simon Wilkes. Here. Dalton Shaw, I will call it 9:30. Mr. Gonzalez, I'll call it 9:15. Is Alonzo Gonzalez here? Here. Okay. Okay. All right, is there anyone whose name has not been called? You believe you should be on the docket? All right, do we have any attorneys that are ready? Strike. All right, court calls cause number CR 23-61, State versus Johnny Lee McMinn for docket call.
Your Honor, from reviewing the discovery, there appears there possibly could be some more discovery that's out there, but according to the state, it may take some time to get that. It's a data dump of a cell phone. We do have a plea recommendation. I do have the rest of the discovery. We're going to be asking for a reset to try to possibly resolve this case without even the rest of that discovery.
What's the rest of the discovery that?
One of the co-defendants' cell phones was seized and a warrant was issued for the data off the phone. That data has not been provided to me. And according to the state, they don't even have it yet.
Your Honor, the cell phone was sent to one agency for download and analysis. That agency was so backed up that this past week we moved it to a different agency to try to get it done sooner, hoping to have it within 30 days, Judge.
All right, Mr. Strike, let's reset. Let's look at October 10th or 12th.
October 10th will work, Your Honor.
10th. All right, court resets Mr. McMahon for another docket call on October 10th. It'll be at 9 a.m. Once you sign, get the yellow copy for you. So, yeah. Are you ready?
Stacy Green.
Stacy Green, CR 2397.
We've executed a PTI contract. Judge, before we begin, I actually tendered PTI fee to the DA's office on my way here, so.
All right, Ms. Green, if you'll raise your right hand. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help me God. All right, Ms. Green, you are charged with the offense of driving while intoxicated with a child under 15 years of age. That is a state jail felony offense. That does carry a range of punishment of not less 6 months or more than 2 years in a state jail prison if you were convicted and sentenced in this case. I see that you want to enter into a pretrial intervention contract to resolve your case with the state of Texas. Do you believe you've had sufficient time to go over this pretrial contract with your attorney, Mr. Brian Schmidt?
Yes, sir.
Are you confident that you have understood everything that you have read over and agreed to in this contract?
Yes, sir.
And has anyone threatened, forced, or pressured you to sign this contract? Mr. Schmidt, do you believe that Ms. Green is competent to enter into this agreement?
Yes, Your Honor.
You've explained to her right to a trial by a jury of her peers, correct?
Yes, Your Honor.
And she's waiving the same in this contract.
Yes, Your Honor.
Do you believe that she's doing so intentionally, knowingly, and voluntarily?
I do, Your Honor.
Also, you've explained to her right regarding a speedy trial and also her right to have an expunction unless those two things are waived. Is that correct?
I have you.
And do you believe that she's understands her decision and that she's intentionally, knowingly, and voluntarily waiving her right to speedy trial and entering into the limited waiver of expunction?
I do, Your Honor.
Right, I see that this is for a period of 2 years.
Yes,
All right, the court, having reviewed the contract, finds that Ms. Green has intentionally, knowingly, and voluntarily waived her right to a jury trial in this matter, that she has had the advice of counsel, who has also entered into the agreement with Ms. Green by signature. The court finds that the state has also waived its right to a jury trial. In addition, the court finds that Ms. Green has waived her right to a speedy trial and has agreed to a limited waiver of expunction in this matter. Court hereby approves the pretrial intervention contract, places Ms. Green on that contract for a period of 2 years. Screen, I'm gonna have you come forward and meet with the probation department. About the contract.
Gonna grab her first.
Read on next.
Donna Drake, Your Honor.
Donna Corey Drake, CR 23-48. Wait, Mr. Schmidt.
Yes, Your Honor. Judge, this is a second docket call. Last docket call, the state had not been able to make an offer. They had not been able to meet with the alleged victim of the case. They since have an offer that's been conveyed to me. We made a counter offer of sorts, and if we resolve this, it would involve a substantial amount of restitution up front, which would require my client to liquidate holdings, assets, if you will. We're asking for one additional reset. Number one, to for the state to consider my calendar, and number two, if we reach an agreement, there's some things that need to be done.
So you think 30 days is sufficient?
I do, Judge. I know well, if we could get that October 10th or 12th date, I think that would be more realistic, Your Honor, if that would be acceptable.
Which one do you prefer?
Either one is fine.
Let's do October 10th.
Thank
Court resets Ms. Drake for docket call October 10th at 9 a.m. Once she signs those, she's free to go.
Thank you, Your Honor. We'll step back and sign that, and that's all I have. This evening.
All right, sorry, Mr. Monitor, I've got you. Big favorite clause.
Yes, sir.
Good morning.
Good morning, Mr. Vargas. Can you see and hear me okay? Okay, I think you might be in the Spanish channel. Okay, excellent. Good morning to you.
That's it, you gotta do it.
Yeah, give it this one. All right.
Sí, sí lo puedo escuchar.
Okay. All right, so Mr. Vargas, what I'm going to do is ask you to identify yourself for the record, state your license number, and then I'm going to swear you. Go ahead. Thank you, Mr. Vargas. If you raise your right hand, sir, do you solemnly swear or affirm that you will make a true translation of the statements of court, the questions of counsel, and the testimony to be given by the witness in the matter now on trial to the best of your skill and judgments? Hope you God. Thank you, sir. Okay. All right, court calls cause number CR 23-135, State versus Alfonso Gonzalez. I believe that we are set here for arraignment and docket says plea as well. Is that correct, Mr. Biggs?
That is correct, Your Honor.
Do I have any victims?
Good.
It might help. Good thoughts. He says that he can hear you. Make sure that, and click it one time and then don't touch it.
In here.
You say, Ram, are you still on this page? Because all this indicates that he can't hear you.
Good.
These are the first check.
All right, Mr. Gonzalez, if you'll raise your right hand. So, Mr. Gonzalez, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
See, no problem.
All right, you can lower your. All right, Mr. Gonzalez.
I have the papers, actually.
Oh, action judge.
All right, Mr. Gonzalez is charged by information with the offense of enticing a child away from custodian with intent to commit a felony, a third-degree felony offense. Mr. Gonzalez. Let me ask you, Mr. Biggs. Mr. Biggs, your client has waived his right to indictment in this case. Is that correct?
That is correct.
And he's allowing the state to proceed with prosecution by way of information. Is that?
That is correct.
Did you discuss with him his right to have his case presented to the grand jury?
I did, Your Honor.
And you believe that today he has intentionally, knowingly, voluntarily waived his right to a grand jury indictment?
He has.
All right, Mr. Gonzalez, do you understand that you have the right to have your case presented to a grand jury? And you understand that by waiving the right to a grand jury, you're allowing the prosecutors to charge you with this offense by information. You understand that as well? For the record, I heard the defendant say C, so. All right, and Mr. Gonzalez, has anyone threatened or pressured you to waive your right to be grand jury today? Maybe threatened it, I. I don't think it's technology.
No.
Mr. Gonzalez, are you waiving your right to an indictment because that's what you want to do to resolve your case? Mr. Biggs, I've got a concern that whatever she's telling him, it's not on the record. And she's, to my knowledge, not licensed by the Supreme Court, so I'm a little concerned that you're not giving him legal advice, or that she is giving him legal advice, not an attorney, and she's not a licensed court interpreter. So if we need to reset this case, go through this process, we can do that. Or Mr. Vargas, how long do I have you scheduled? Mr. Vargas, if you're talking to me, I can't hear you. I'm in English. Mr. Biggs, what do you want to do?
Your Honor, if I could have a few minutes with him, I don't think the problem is that he doesn't understand the questions you're asking him. I think he may be having trouble hearing the interpreter because the topics that you're discussing with him, I just literally had with him 15 minutes ago. So I know he understands the process. If I could.
So let's do this. Let's have him tell her what the issue is. She tell me, I'll tell Mr. Vargas.
Says it's just, whenever you're speaking, he's translating at the same time, so he's trying to hear both of you speak, so he's getting confused.
He doesn't see the purpose of a translator, so he doesn't hear me, because I'm an English speaker, he's a Spanish speaker. Mr. Vargas, that's the one he needs to be listening to. If he understands English, we don't need an interpreter.
He understands broken English, not well enough to make it through a hearing.
Okay, then he needs to focus on Mr. Vargas and not worry about me. And so Mr. Vargas is going to repeat everything that I say into his natural language.
Try again, Judge.
Try again. All right. All right. So, Mr. Vargas, you ready? All right, Mr. Gonzalez, you are waiving your right to an indictment in this case because that's what you want to do as your sole decision so that you can resolve your case by plea agreement. Is that right? And you talk to your attorney about what it means. Thank you. And you talk to your attorney about what it means to waive your right to an indictment, correct? And you understand it. You've also waived your right to a jury trial in this case. Is that correct? And no one has threatened you or forced you or pressured you to waive your right to a jury trial. Is that correct?
No.
You made the decision by yourself to waive your right to a jury trial, correct?
Sí.
And you've also waived a right to a speedy trial. Is that correct?
Sí, correcto.
You've also agreed to what is known as a limited waiver of expunction, meaning that if you complete this contract, not all of your criminal records will be expunged. You understand that?
Sí, sí, entendí. Sí, sí, lo entiendo.
Okay. And you have had an attorney during your case, Mr. Biggs. Are you pleased with Mr. Biggs as your attorney?
Sí, estoy de acuerdo. Sí, estoy de acuerdo.
Okay. And Mr. Gonzalez, where you have signed this paperwork and you put your name in here, are you swearing that that is your true and correct signature? And you only sign these documents because you understood what they said and you agreed with them?
Sí, estoy de acuerdo.
All right. And Mr. Biggs, you have used the use of a translator from English to Spanish to consult with him. Is that correct?
I have, Your Honor.
And you've explained to him all of his rights as they pertain to this case and specifically to the terms and agreement of this pretrial intervention contract. Is that correct?
Yes, Your Honor.
Do you believe that he understands everything that he has read and signed in the contract?
I do, Your Honor.
And you do not believe that he has been coerced in any way by yourself, anyone in your office, anyone with the government or in court today? Is that correct?
He does not.
All right, the court's going to find that based on the testimony from the defendant, that the defendant intentionally, knowingly, voluntarily has entered into the pretrial intervention contract and as a result has waived his right to an indictment in this case, has allowed the state to proceed with a prosecution with information, has intentionally, knowingly, voluntarily waived his right to a jury trial for this matter as part of the agreement, has intentionally, knowingly, voluntarily waived his right to a speedy trial and a limited waiver of expulsion. Or will prove the court finds that the defendant has also entered into a stipulation of evidence wherein he has admitted guilt on or about April 30th in Van Zandt County, that he convinced a child to leave the campus of high school without the consent of the parents with the intent to commit a felony as documented and signed in the stipulation of evidence. Court hereby places Mr. Gonzalez on a pretrial intervention contract for a period of 2 years. Mr. Gonzalez, do you have any questions for Mr. Biggs for the court today? And Mr. Gonzalez, are you guilty of this offense?
See.
All right. Court will accept the plea of the defendant. Obviously, that will be taken under advisement until the completion of the contract. All right, Mr. Gonzalez, I've signed your paperwork. If you do not have any questions, then I want you to come forward and meet with the probation department. The officer here, and they'll give you more information about what to expect next.
Thank you.
Thank you. Biggs, are you ready on your next case at all?
Yes, Your Honor.
Just go ahead and call that one. That's your last one, correct?
Yes, sir.
Yes, Mr. Vargas. Yes, sir. I believe that is it. I thank you. I appreciate your help working with us, being patient while we're working through those difficulties. Yes, sir. Thank you. Have a great day. All right, Gregory Horton, CR 23-99. Go ahead, Mr. Biggs.
Your Honor, we don't need a pretrial on this case today. I anticipate that this case is going to be resolved without a jury trial, considering the court's ruling from our last hearing. Conda and I haven't actually flushed out the details of what that's going to look like. So if we could just get our next pretrial date next month, I think that the case will be resolved prior to that school date.
That's
Right.
correct. That's correct, Your Honor.
That's correct. All right. Set on one of the three following dates. September 19th, 21st, 26th, 19th, 21st, or 26th.
The 19th works, Judge.
All right, Mr. Horton, you're reset for docket call September 19th. 9 AM, which is on his own parents.
Under Mike's name. Yes,
Oh, it's in.
yes, Your Honor.
All right, court calls number CR 22376, State versus William Murray. Actually, we were set for a plea today. I know that we had a bunch of continuance, I think late yesterday afternoon.
Yes, Your Honor. Do you mind if I just kind of put all out there? Okay. Judge, long story short, we have an agreement. The agreement is for my client to plead guilty and be time served under 1244B. There's a substantial fine of $5,000. He was to have half that today. That is in our IOLTA account, but he is working in Colorado, and after getting that money together, did not have the means to get here today. And so what I'm asking the court to do is basically give us 30 days, maybe that September 21st day, so that he has time to get here, so he can execute that plea bargain. It's my understanding the state has agreed not to take a position regarding our motion for continuance.
That's correct, Judge.
You have Mr. Goldner here via Zoom so that we can have him on the record. He understands the reset date.
I can do my best to get a hold of him right now. Can I have you excused briefly?
Let's do that and then stay, then the court will grant, parents' rights.
Thank you very much.
Do you have that number, Mr. Juan?
Is it the same one or is it changed?
It's the same one.
Okay.
I can pull from email.
Okay.
So I've got to do one more Zoom hearing. Mr. Woodward here. Yeah.
Out, out. Go.
Hello?
Hello, good morning, Judge.
All right, good morning, Mr. Woodward. I believe that was probably your client, or maybe someone at the ISF facility. Is someone at the ISF facility present on Zoom?
Yes, this is actually Dalton Trot.
All right, Mr. Trot. Mr. Trot, do you know, does your facility have the ability to appear with video or only on?
No, Your Honor.
You don't know? All right. All right, so appearing via Zoom today is Mr. Woodward with Mr. Dalton Trot, who is in ISF facility in Thurston, Texas, who is appearing via audio via Zoom. This is cause number CR 23-00144. State of Texas versus Dalton Wayne Trot. Mr. Woodward, had we had an opportunity to go over the indictment with your client, Mr. Trot?
I have, Your Honor.
And are you ready to proceed with arraignment?
We are. Would you like me to arraign him, Your Honor?
Well, no, I didn't know if you wanted to waive arraignment. Do you want me to have the prosecutor read the indictment? I didn't know if you wanted to waive the formalities of arraignment.
I do, Your Honor. Yeah, we have, Mr. Trott and I have gone over the indictment. He does admit he is Dalton Wayne Trott, the same person charged in the state's indictment. He waives formal reading of the indictment and any further formal arraignment, enters a plea of, excuse me. He does not need to enter a plea. I apologize, Your Honor. If he were to be required to, he would enter a plea of not guilty.
Yes, he is required to enter a plea at this time.
Yes, sir. So he would enter that plea of not guilty.
All right. You explained to him that he is charged with a first degree felony offense under Health and Safety Code with a range of punishment of not less than 5 years or 99 years for a life if convicted and sentenced.
Yes, I have, Your Honor.
Okay, all right. Court finds that Mr. Trott has waived the formal requirements of arraignment or will enter his plea of not guilty into the record. And the court's going to set this matter for a pretrial hearing. Mr. Woodward, have you spoken with the DA's office, arranged access to the digital discovery?
I sent an email and I believe I received a response yesterday, Your Honor. I've not opened that yet. I will this morning.
Okay. And so remind me, your client, I know you sent the ISF. I'm trying to recall the detail from your motion, but remind me when he's expected to be out of those.
That program, as Your Honor, as you are aware, is anywhere from 45 to 120 days. He left Rockwall County approximately 10 days ago. So he should be there at least another 80 days.
Court's been set this for pretrial hearing. I'll set this at the end of October. I know he may not be out at that time. If he's not, then he'll just notify the court. We may be able to just continue that. But if he does get out, I'd like to put having here in person October 24th.
Yes, sir.
If he's then that'll be at 9 a.m.
Yes, sir.
And in the meantime, I want to be assured that you'll be working with the state on getting all of the discovery, both what's available digital, and if there's any physical discovery such as audios, videos, and pick those up and have those in your possession so that you can make a decision. If there's any pretrial issues, test motions, practice in this court is that after arraignment, what I would be, I'd set the case for pretrial like I have done today. And then at that pretrial setting, I think here, if there's any contested pretrial issues such as suppression, motion to quash, things of that nature, anything that's going to be evidentiary in nature would then be set on an evidentiary docket. And then once if there is no issue with an evidentiary docket, or there is, and once we pass the evidentiary docket, then the next setting would be docket call. And that would be the time that I would expect to hear whether or not there's going to be an agreement or a request for a jury trial. Okay.
Yes, sir.
So I will see you back on October 24th. Mr. Trott, you've heard everything in court today, correct?
Correct.
All right, so if you get released from that ISF facility, then you're to appear in person on October 24th at 9 a.m. at 294th District Court in Van Zandt County. If you're still in custody, I'm sure that Mr. Wood will contact the court and we may appear again this week. Okay.
Yes, sir. Thank you.
Thank you, Mr. Woodward.
Thank you.
Yes, sir. May I be excused?
Yes, sir. Thank you, Mr. Woodward.
Yes, sir. Thank you.
Hello?
Yeah, give me just 1 second, Mr. Trott, and I'll get you removed.
Okay, thank you very much.
Just makes you glad we're not doing everything. There was a time.
Yeah. Mr. Golder, we'll just press that button. There you go. There you go. Okay, do me a favor. I know you're outside. I know the sun's there, but I need you to take off your hat and your glasses.
Sir, I'm sorry.
Said, I know you're outside, but I need you to take off your hat and your glasses for me.
Okay, I can't see outside.
Yeah, go somewhere where you got some shade or something if you need to. Or sit in your truck or something like that.
Is that better?
Yes, sir. It works for you. Works for you. All right, this is cause number CR 22376, Day versus William Corey Goldner. The court has already received the announcement from Mr. Weiner regarding the request to reset. The court is going to reset this case to Mr. Goldner to enter his plea. We said
That'll be fine. I was thinking September, but October gives them more time. That's,
either or, I'm fine with it.
let's do October 12th, just to be super careful.
All right, Mr. Goldner, for this order, you hear the person on October 12th. Here in the court at 9 a.m. Before the court, you understand that?
I'm sorry, my service is in and out up here in the mountain, sir.
Okay, can you hear me now?
Yes, sir.
Okay, I've reset your case to October 12th at 9 a.m. Mr. Weiner's here in court with me today. We're going to enter your plea on that day. You understand?
Yes, sir.
Okay, we'll see you on October 12th. You're free to go.
All right, thank you.
Thank you. Maybe excuse, sir. Appreciate your patience.
Thank you.
All right, well, so try to stand us back in order. Mr. Godwin, CR 23140, CR 23141.
Today's range.
Have you seen the indictments? You have copies of those. You need to know those.
We're gonna be waiving the indictment.
All right, Mr. Godwin is set for arraignments on unlawful possession of firearm. And also possession of controlled substance. Go ahead, Mr. Hawkins.
Thank you, Your Honor. The name and his name is correct as stated in the indictment, Your Honor. He waives the formal reading. He's aware of the range of punishment for the misdemeanor A is up to a year in jail. The secondary felony is up 2 to 20. Officer range is $10,000 fine. And enters a plea of not guilty as to each charge this time, Your Honor.
Thank you, Mr. Hawkins. Court finds that Mr. Godwin has waived the formal requirements of arraignment. Court enters his plea of not guilty into the record on each charge. Court sets this matter for pretrial hearing. Be available on September 19th, 21st, or 26th.
Judge, I checked my schedule and at this time, September the 21st looks to be the best day.
All right, court sets Mr. Godwin then for pretrial September 21st at 9 a.m. Once you sign your notice of hearing, the yellow copy.
Thank you, Your Honor.
And Mr. Godwin, the pretrial release department is asking to see with you before you go to visit with you. All right, this will talk to Mr. Hawkins, come back. Yes, Your Honor. Standards already, sir. Not very day. Jeremy Snells, Mr. Snelson. CR 23119 120. Nelson set the pretrial on both cases.
Yes, right. And Judge, we don't have any pretrial matters in either case.
There being no pretrial motions, the court sets Mr. Snelson in for docket call. September 19th, 21st, or 26th.
Judge, I would say the 21st work.
Court sets Mr. Snelson for September 21st, 9 a.m. in each case. And once you sign your notice, you're free to go. Like to call first.
Nathan Ojeda.
Nathan Ojeda, CR 23115. Set for pretrial.
That's correct, Judge. No contested pretrial has to be set for docket call.
All right. Court will set Mr. Ojeda for docket call. That's All right, it's my understanding that the state, has an announcement.
Yes, Your Honor, state's going to move to dismiss this case while Mr. Ojita's compliance with the sex offender requirements was not perfect. He did make an effort to comply and did make reports, although not to the proper authority. So because of that, Judge, we're going to dismiss this case in the interest of justice.
No objection. All right, for my saying more motions to dismiss, or by grants that motion, Mr. Ojita, ready to go. Kenneth Taylor. Taylor, come on board. It's gonna be CR 2195. Taylor is set.
Correct, Judge. We have no test pretrial aspect.
Right, we're all set, Mr. Taylor, for docket call on September 19th or 26th.
19th is fine.
19th. All right, board sets Mr. Taylor then for docket call September 19th at 9 a.m. Once you get your notice of appearance, you're ready to go. You're all good, Mr. Taylor. All right. I see you ready. Who'd you like to call first, Mr. Travis?
Going out, I guess.
Carlos Gatlin, CR 21288. Gatlin, it's docket call.
Yes, Your Honor. We just need to get a trial setting, I think, for Mr. Gowan. We good to go.
So, Mr. Gatlin, y'all have exhausted your plea negotiations, if there were any at all. Mr. Gatlin,
There was a plea offer made and Mr. Gowan was opted to go to trial.
your client understands that if the board is not going to accept the plea agreement after docket.
Yes, Your Honor.
All right, we'll do it. Mr. Gatlin, then he's asking for jury trial.
Yes, Your Honor.
We'll set Mr. Gatlin to get the jury trial. On Monday, October 2nd. So, Mr. Gatlin, on Monday, October 2nd, will appear at the courthouse. The case will not go to trial that day, okay? But you'll appear here, you'll check in with my staff, they'll be downstairs, they'll give you more information. You'll continue to do that. They'll give you a reset date. Continue to do that until your case, either it's selected in trial. Mr. Adams will not be part of the meeting here, so your case appears in the top 10 cases for trial. Mr. Adams, All right, this is file number CR 22-334, State versus John Houston. Junior, we are set today on status of the Department of Family Protective Services records in the state social. I believe that the state has in fact received those records today, or they received them and are able to submit those for today.
Yes, Your Honor.
The court will reset the files for the review, and we will reappear on this case October 24th at 9 a.m. Thank you.
No, that's all I have. So
Yes, any questions?
Your Honor, we call, Miss Price, she's out in the hallway.
Does she need a mask? We probably would. Here's what I think. Maybe good there. Long. Sounds great where that is. And it must. Don't let this. It's time to check. Alright, this is CR 22-339, State versus Wendy Lawson Price. Are we entering a plea today, Mr. Mike?
Your Honor, we still intend on entering a plea, but the state, as part of the plea agreement, is filing an additional case. It's going to be a waiver indictment. So if the court could reset this for like September 21st, they can.
The objection from the state?
No, Your Honor.
All right, court will reset Ms. Price plea on September 21st at 9 a.m. Ms. Price, once you sign your notice of appearance, you're free to go. Who you ready on next?
Ms. Cabiny.
Ms. Cabernet. DR 18-465, pretrial.
Your Honor, we don't have any additional pretrial motions to file. We'll abide by the court's standing order. Ask the court to move this over to docket call.
All right, any specific time request? All right, court sets this case for docket call. September 1st, 9 a.m. Notice of appearance, you're free.
We call Ms. Jacobs.
Tracy Lane Jacobs, CR 23-100. Really, Ms. Jacobs is set up control.
Your Honor, Mr. Harwell's going to be checking on something from a store owner for me for additional discovery. If we could reset that to September 21st, I think that should be sufficient.
Yes, Your Honor, still waiting to hear back. There could be, a little bit of follow-up, that Mr. White asked, and I agree, to be useful.
All right, the court will reset Ms. Jacobs for an additional pretrial hearing September 21st at 9 a.m. When she signs.
Mr. McClanahan.
Brandon McClanahan, CR 23-109-10. McClanahan, 73 trial cases.
What were the cause numbers? CR.
CR 23-109.
Your Honor, we on this case, we're still attempting to kind of finish up some investigation. It shouldn't take too long. We just asked for today for September 21st.
Or Dr. Paul or
For pretrial.
objection by state.
No, Your Honor.
All right, court says Mr. McClanahan for additional pretrial September 21st. At 9 a.m.
Yes, sir.
Once he signs.
Your Honor, we're just waiting to get the paper from Mr. Business.
What do you mean?
So.
All right, John Casey Dunlap, CR 23-49. All right, the court has not, I believe the court has conducted its ruling. Have you received a ruling from the court?
No, I haven't, John.
Let me double check this. Yes, so the court is not completed its review link on the defendant's motion to strike enhancements. So I want to reset this for additional document. I think I had that finished here pretty quickly. So it'd be either September 19th, 21st, or 26th. Be better.
Let me take. I believe 21st would be best.
All right, Mr. Dunlap, court resets you for docket call September 21st. That'll be at 9 a.m. And once you signing, they'll have you reading. Thanks, sir.
I believe that's all I have here.
Thank you, Mr. White. Wheeler. All right, this is sanctions court hearing CR 18-342. See Mr. Wheeler at the last board setting. I gave you some things that you had to do. Pay your probation, fees, pay your restitution, do your community service. We did all three of those. So it looks like everything's going well. I'm gonna reset next month. Same parameters, same amount of probation, same amount to restitution. You know what those are, right? And 20 hours of community service. I think we can do this enough and get you to where you're doing that consistently. We can get you out of this sanctions court, okay? So I'm gonna reach back on September 26th.
And
Andy Jones. Andy, come up here and see Officer Ventura. Right, please. Actually,
it's $2.
all right, let's see. Last time the sanctions court, we're here to pay approximately $130 probation. $100 for collection, community service. Looks like you got your community service done. Paid most of your probations.
And I just paid court costs this morning,
Okay, what did you pay there?
120.
20 court costs. All right, so I'm gonna reset you for September 26th. So it's gonna be the same thing, $134 for probation. And it's that amount to get you to expire on time, without having to extend you. 134 probation, 110 to court collections, 10 hour community service. And I need you to enroll in your drug offender education.
Second September, right? Really good.
The drug offender, not sure.
Yeah,
Probation
I'll talk to Chuck about it.
Yeah, they'll know. I just need you to enroll in it. Okay, whether you started or not, as long as you get enrolled,
Can I do it online or do I have to do it,
you'll need to file a probation on that. I don't. Okay. All right, so we're gonna reset you to the 26th.
That's on a Tuesday, right?
The 26th is a Tuesday.
I'm off on Tuesday, so it works.
26th is a Tuesday. All right, Mr. Tabor is gonna bring you this notice, sign that, and then come see the probation officer. Hello, sir. How are you?
Good morning, Your Honor. Thomas Norman.
Who are you representing today?
Thomas Derek Norman.
Oh, Norman, okay. This is cause number CR 23-64, State versus Thomas Norman. We are selling plates today. We're going to enter our plea.
Yes, Your Honor.
All right, Mr. Norman, if you'll raise your right hand. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. Yes, sir. All right. Your name is Thomas Derek Norman, is that correct? Yes, sir. Mr. Norman, are you a United States citizen, reads, writes, and speaks English? Yes, sir. Have you ever been diagnosed with any type of mental condition? No, sir, I have not. In this case, you're represented by your attorney, Mr. Elliston. Are you pleased with him as your attorney? Yes, sir, I am. You feel like you've had enough time to talk with him about your case and that you've had all of your legal questions answered? Yes, sir, I have. Is there anything about the paperwork that you've read over and signed today? No, sir. Mr. Elliston, do you believe that your client, Mr. Foreman, is competent to enter into this plea agreement?
I do, Your Honor.
You've explained to him all of his rights as they pertain to this case.
Yes, Your Honor. We do have a couple of things I wanted to bring up, though, at the appropriate time.
Okay. Let's go ahead and bring those up at this.
Okay, the prosecutors recommended 2-year supervision, community supervision, and I'm going to ask the court to make that a year instead of 2 years. The other thing is there's on the community service hours, I was going to ask for about half or less than half of what is on the paperwork there. But besides that, those are the only issues we had.
Typically, I don't accept a plea agreement that's not agreed. So if the agreement was 2 years.
Well, we have discussed this with Ms. Curry. Ms. Curry understood that I was going to bring this to the court's attention. She said it's the court makes the decision on the community service hours and on the length of probation. So she knows that she knew I was going to do this.
That's correct.
Judge, our offer is 2 years deferred adjudication. I did explain that the defendant, if he's in compliance, can seek early termination. But I also did in fact tell Mr. Elliston that we do not negotiate terms of the community supervision. That is the court's community supervision. The court imposes those terms in conjunction with and on the advice of the probation department. I also did inform him that the probation department prefers that we not do 12 months, that short of a period of community supervision, because they feel like it doesn't give them time to get the person up and running and going and getting everything done. So that's our offer for 2 years deferred, but he can apply for early termination.
Mr. Ellison, why would your client want half of the hours of community service? That's standard order of this court. What would be the reasoning?
Well, 160 hours, that's a lot, Judge. And he's been on community service through the misdemeanor section here previously. We ran into all kinds of problems because they were, even though the 2 cases that he got deferred adjudication on were to run concurrent, probation officers did not understand that. And they were trying to stack it on top of it, and I had to get a court order to get it corrected. So he's done all of the community service and everything else that he's supposed to do in those cases. And so he really doesn't need another 160 hours of community service.
Saying that he's already done community service on this case?
Not on this case, no.
So what was your argument again? That he was on misdemeanor cases here?
Here,
Van Zandt County.
yes,
He had community service.
right.
And he did on 2 separate cases. And he did community service. They were supposed to be run
They
concurrent.
concurrent, and the probation officer trying to stack it. So I had to get a court order to straighten it out.
Okay.
So,
how does that have a bearing on this case?
well, he's already done a lot of community service, Judge.
On this case?
Not on this case.
So then he hasn't done community service. I mean, So you're telling me that he did community service on 2 other criminal offenses that he pled guilty to?
No contest, I think was plea, but yes.
Okay, so. So we're talking apples and.
Well, I know that the court has the discretion to reduce that, so I'm asking the court to exercise its discretion to reduce it and reduce the amount of the length of probation as well.
Court's going to deny the defendant's request this time. Does Mr. Norman still want to go forward with the plea agreement?
Yes, Your Honor.
All right, Mr. Norman, you were originally charged by indictment with a 3rd-degree felony offense of assault on a family or household member by impeding breath or circulation, a 3rd-degree felony. It appears that the plea agreement in this case is to reduce that charge to a Class A misdemeanor offense of assault that causes bodily injury, lesser included offense. And for the court to defer a finding of guilt, place you on 2 years of community supervision. A $500 fine, court cost, reimbursement fees, and as a special condition of community supervision, no contact with the victim during the probationary term. Mr. Norman, is that your understanding of the plea agreement?
Yes, it is.
All right, Mr. Norman, then at this time, how do you plead to assault causes bodily injury, Class A misdemeanor?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, Your Honor.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
Word accepts the defendant's plea of guilt. Mr. Ellison, any objections to the stipulation of evidence in this matter?
No, Your Honor.
Stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial position. Is there anything further from the state?
No, Your Honor.
Is there victim compliance or anything of that? Or being assaulted?
We're in compliance, Your Honor. The victim is actually in jail currently for assaulting Mr. Norman.
Anything further from the defense? Mr. Ellison?
No, Your Honor.
All right, court's going to review the stipulation of evidence. All right, the court has reviewed the evidence, finds that there is sufficient evidence to convict Mr. Norman will follow the agreement in this case. The court hereby defers a finding of guilt, places Mr. Norman on community supervision, Class A misdemeanor offense, assault causes bodily injury, Class A misdemeanor. Court defers that for 2 years community supervision, $500 fine, $270 court cost, $35 reimbursement fees, and Mr. Norman is ordered to have no contact with the victim in this matter during the probation period. Okay, so on the trial court certification of appeal, it's checked off that it's not a plea bargain case. The defendant has the right to appeal.
No, Your Honor. That's a mistake.
All right, the court's going to, I'm gonna give this back to you, Mr. Ellison. Have your client initial? The court's gonna check off this. It is a plea bargain case. The defendant has no right to appeal and the defendant has waived rights to appeal. So if you could mark out that box, you and your client sign that, or at least initially. All right, Mr. Norman, your body. hereby remain as department, so they carry out the terms and conditions of the sentence. Here in me, officers. Mr. Arnold. Oh, it's paperwork. Okay, I'm sorry. We're gonna stand and recess. I would recommend standing in the courtroom, but we make sure that the competition is not biased.
One day I don't bring a gun.
Right, that's.
Okay.
We said for 15 minutes.
You too. Be safe. All right.
I think so.
Yeah, and I'll make sure that I have all the stipulations for the section done. Yeah.
Still people. Good morning. How are you? I don't know. I'm good. I've got a Reginald Young. He had been in jail. He just bonded out a couple of weeks ago. And I got an offer. It's paid to do. Oh. Okay. If we want to try to make a deal. Okay, yeah, I haven't spoken with him since, I don't know, June. Okay. He'll come in. I'll bring. Okay.
All right. We'll look over.
All right, good to see you.
All right, Mr. White, who are you ready?
Mr. Wilkes, Your Honor.
All right, this is cause number CR 23-82, State versus Simon James Willis.
Your Honor, we were set for plea on this. We haven't had a paperwork deal, so we're gonna have to ask court to reset that for September 21st.
No.
All right, that's Mr. Willis Sanders' plea on September 21st. That'll be at 9 a.m. Soon.
Cases.
Yes, and so once you sign it, it'll copy it for you.
Thanks.
Jay. Easy one.
I'm speaking with the prosecutor real quick about that case. Judge.
Okay, any more time?
Yes, just a few
Please,
minutes.
Your Honor.
Early veteran. I'm saying that right? All right, this is file number CR 18-150, state versus Kimberly veteran. Legislature, I'm sure that request to amend your community supervision to extend your probationary period for another 6 months. Looks like you're set to expire on September 11th of this year. You understand an extension would move you to March 10th of 2020. Is there a reason that we're needing to extend you for 6 months? You believe by extending your probationary period, you'll be able to apply and stay in compliance with paying your fees and doing your community service? If anyone threatened or threatened you, force you or otherwise try to influence you, make you think you had your 6 months. All right, we'll extend this venture for an additional 6 months. Your new expiration date is March 10th, 2020. All right, we'll be here at the office of Sheriff, and you'll be pretty. Sir, if you want to wait here on the hallway, you're going to meet with them, and she'll come out back. Lanaria Miles, CR 2239. All right, Ms. Miles, there is a motion to revoke that has been filed in your case. How do you plan on resolving your case? Are you going to represent yourself? Are you a hired attorney? Are you requesting court appointed attorney? Can you speak up a little bit louder?
Right now, I have a court appointed lawyer, so myself. That's the previous.
And she has a court appointed lawyer until she hired. Do you have the funds available to hire an attorney? So are you planning on hiring an attorney? When do you plan on doing that? Do you have a time frame? Next week, next month? So have we appointed? So the court would appoint Mr. Jonathan Manning. It's my understanding that you told my indigent defense coordinator here that you did not want him. Well, you do have a choice. You can hire your own attorney. Or you can represent yourself of your choices.
Right now,
Okay, all right. Or that's Jonathan Manning. Reset this matter for. All right. Go ahead.
I can start on the 13th.
September.
Yeah, I don't think I'll make the show.
Are you gonna be induced that day? That's your due date, okay. I'm gonna set you on November 9th. It's gonna be 7 weeks after your due date. Give you time to have a baby, get back on your feet. Okay, it's gonna be Thursday, November 9th at 9 a.m. Okay, sign this for Deputy Martinez. I'll give you the yellow copy. And then I want you to look here and check the probation. Okay. Ryan Smith. All right, this is call number CR 19-207, State versus Ryan Emmanuel Smith. Mr. Smith, you have been charged with the second degree felony offense of possession of a controlled substance, penalty group 1 between 4 grams and 200 grams. That does carry a range of punishment of not less than 2 years in prison or more than 20 years in prison. It carries a fine not to exceed $10,000 if convicted and sentenced. Do you plan to hire an attorney, represent yourself?
I'm consulting with Justin White right now. Leave to be able to hire him. However, it's not going to be as of yet.
It's not gonna be what?
It's not going to be as of yet. I don't have the retainer fee yet. I would like to ask for possibly a couple weeks to get it together. He's working with me and he's been more fair about it, but I just don't have it.
I think this is the second time we've talked about this, right?
You told me last time to come down here and give you a list of attorneys that I spoke with. See if I've chosen one of them. I'm 90% sure that it's going to be Mr. Wine.
Have you spoken? What other attorneys have you spoken with?
Mike Head, Kyle Steele, this Dixon, Leslie Dixon. I'm still yet to call Mr. Brian Smith. I haven't been able to get him on the phone. I thought I called quite a few.
All right, so if I give you 30 more days, can you have an attorney?
I believe so.
If you don't have an attorney in 30 days, then we're gonna have a hearing about your bail.
Yes, sir.
Make sense?
Yes, sir.
You can afford a bondsman to be out. Then, and you don't take care of your business hiring an attorney, then I'm gonna consider whether your bail is sufficient. I may revoke it, and put you back in jail. Okay, all right, I'm gonna reset you for 30 days. I'll set you on September 20. Let's do September 26th. At 9 a.m. All right, Mr. Stevens, you ready?
Yes, sir. Reginald Young, Your Honor.
All right, Mr. Young. This is cause number CR 21-98, State versus Reginald Floyd Young second. We're on status today.
We are, Your Honor. Mr. Young recently bonded out of jail. We haven't had any conversation probably in 6-8 weeks, something like that. He recently bonded out. We got notified of the court. I met with him for the first time in quite some time.
I don't believe the prosecutor is quite up to speed on the case, so we're gonna respectfully ask for another status setting judge, see if we can resolve this before it gets on the trial docket.
Stevens, I'm not really inclined to do that. I think what I'm more inclined to do is leaving back on jury selection. We've been through arraignment, pretrial, docket calls. Been 10 jury selections. And then he absconded. So I really don't want to go backwards on that.
Okay, Judge.
Waiting for that. So I'm gonna put it back on the trial docket. Getting next week. Okay. So, you know, the drill, Mr. Young. Downstairs at 8:30. Mr. Stevens is not gonna have to be here till you get in the top 10. And if you don't check in and I have to go and arrest you again, the bail will be so high that you will not be able to make it, and I will keep you in jail until it's time for your trial, so that I can be assured that you'll return to the jurisdiction of this court. Understand?
Yes.
All right. And if you think you want to work something out with the state can still work on that, then y'all announce something to the court, I'll consider it. Okay,
Thank you, Judge.
all right, we'll see you next week.
That was August the 28th, correct?
Yes, next time.
I mean, excuse Judge.
Yes, sir, good see you. Andy Jones. All right, this is sanctions court hearing. Nancy Joe Jones, CR 1797. See Jones. The last time we were in sanctions court. Two things that I ordered you to do. One of them was to pay $65 to probation. Says you did not comply with that.
Just paid $100 on it.
When,
Friday.
when we were supposed to have it done.
I was already a month ahead, so I just said I was 35 and then 65, and I just paid 100 on it, so I just paid.
Right. Says you complied with your court costs of 55 and you did your community service. Where you, while she's checking on that, where are you doing your community service at?
Edgewood.
At the Heritage Park? That's what I thought. I'll let her check on that. If it's a records issue, we'll get it there. Well, they set you for a Tuesday or a Thursday. Is one of those days better than the other?
Either one of them.
All right, Ms. Johnson, I'm gonna reset you to September 26th at 9 AM. We're gonna do the same thing, okay, $95 to let's say $65 to probation, $55 to the court, 10 hours community service, okay? All right, June Martinez is gonna bring this. If you sign where it says defendant. And I will put down one, Jim, this is back on 3.6, okay? This one is this morning's criminal docket, which is going to stand in recess at 21:30.